Honorable Mr. Justice Witt, Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados. Hearing of appeal in CCJ Appeal BBCR number 4 of 2020 between Grenville, Ricardo, Delpeache, and the Commissioner of Police. This morning's 5-member panel comprised their honors. Honorable Mr. Justice Witt, presiding judge.
Good morning, Council.
Honorable Mr. Justice Anderson.
Good morning, Council.
Honorable Madam Justice Rajnatli.
Good morning, everyone.
Honorable Mr. Justice Barrow.
Good morning, all.
And Honorable Mr. Justice Burgess.
Good morning, Council.
May we have the appearances, please? Thank you.
If it pleases this honorable court, I am Andrew Pilgrim, and with me is my learned friend, Ms. Rashida Edwards, and we appear for the appellant, Delpeache.
Good morning, Your Honors. May it please this honorable court, my name is Olivia Davis. I'm appearing in association with Mrs. Crystal Delaney for the respondent in this matter.
Yes, thank you very much. I think we will start with Mr. Pilgrim. Mr. Pilgrim? You are muted, so.
We go.
You can speak now.
Grateful, Your Honor. It just seemed to be a little delay with the mute button. We were pushing it and getting no response. We apologize. If it pleases this honorable court, we will seek to rely on our submissions in writing, but I wondered with the leave of the court whether we could look at ground 2 first, as we seek to make the point that the Crown's position seems to be that their incorporation is irrelevant and that the fact of incorporation has no bearing whatsoever on this case. That's what I understand their position to be essentially. And in respect of ground 2, they are saying...
Mr. Pilgrim, it will help me if I get clear from the beginning that submission, because I got the sense that what the Crown was saying was that incorporation exists. We did not go after the incorporated entity. We had a right to go after the individual without also going after the incorporated entity. Therefore, Section 22 is irrelevant. Help me there, please.
Malad, it seems to me that all parties are agreed that the entity committing the offense is a company. It's a company that makes the orders. It's a company that owns the property. It is Ouch Boutique that performs all these tasks.
And again, you need to help me there, because if the company is not charged, but only the individual, how can all parties be agreed that it is the company committing the offense when it is the individual who is charged and convicted? I really do need your help.
Well, Your Honor, how we seek to approach that is to say that incorporation must have some meaning. If I incorporate a company and I use that company to perform my business, that must have some meaning. The creation of that person is my right, and the existence of that person must have certain things flowing from it. And while we say it's open to the Crown to say that they believe that Mr. Delpeache is the person in the company, that's fine. But there are certain techniques by which they must get there. And by the same token, if the Crown is of the view that this type of situation arises, Section 22, we say, provides a protection so that it goes beyond the Commissioner of Police, and that the DPP has an oversight on these issues. And that section creates a protection for a person in Mr. Delpeache's position. And it ensures that someone above the Commissioner of Police's level is overseeing whether there are issues related to the incorporation that should affect how the matter is dealt with.
Mr. Pilgrim, before you go further, it bothers me as I sit here that the Crown has not said that they do not agree with your first proposition, which is that all parties agree that the entity committing the offense is a company.
That's my understanding.
Is that Ms. Davis? Ms. Davis, is that the proposition that is agreed to by the Crown? Because I certainly, like Justice Barber, did not get that impression.
No, my lady, I didn't. I was taking a note of that when it was my turn to speak, ma'am. But we were not agreed that the company was the one who performed the offense. Our position is that we could have gone against Mr. Delpeache in his personal capacity, ma'am.
That was the impression I got. Yes, Chair.
And I also got the impression that you had said that we could have gone after the company too, but we didn't. Is that correct?
Yes, that was included in my submissions as well, Your Honor.
Okay. So so that is the first part of the submission. Mr. Pilgrim.
Mr. Pilgrim, you'll have to take it from there then, that all parties are not so agreed, and give us the assistance that we would need. Thank you. And I believe you've gone back mute.
Yes.
Again, sorry, ma'am. We just seem to be getting a delay when we push that button. And perhaps it's more appropriate for me to say then that the Crown accept that they could have gone after either party.
Yes.
But my understanding of the impact of that is that they understand that Section 22 applies, because Section 22 is saying if the offense is committed by a company, in other words, and we're not at the stage of conviction. So they're in a position where investigators is saying this offense has been committed by a company or has been committed by the defendant. And we're suggesting that from the time that question arises, the Crown have a duty to take this to another level, to the level of the DPP.
But Mr. Pilgrim, are you hearing me?
Yes, Your Honor.
Does Section 22 apply, or the more specific provision in 50E, as the Crown is suggesting?
Well, it would be our position that the general provision contained in the Interpretation Act would apply, and that a later specific provision cannot now amend away the right that accrues to the defendant in the earlier act.
But is this isn't the principle of interpretation, the generalis specialibus non derogant rule, doesn't that apply to interpreting Section 22 in light of Section 50E?
I think we read that rule of interpretation differently to the Crown. Our position is that if there's a general provision set down first, the latest specific provision does not automatically oust that earlier provision. It's the other way around.
So what is the principle which of interpretation which you are invoking there? Because it would seem to me that the existing provision would have been known to Parliament when Parliament passed the 2001, I think it was, or whenever, amendment to the 1984 Act, to the Interpretation Act.
Your Honor, if I can refer you to our response to their reply at page 841. Looking at paragraph 30.
30?
Yes, ma'am.
Thank you very much, Mr. Pilgrim.
our understanding of that maxim is that the general words in a later statute could not exclude the specific provisions in an earlier one. And that is the rule as we understand it. So I don't see that that rule can be invoked here to say that the interpretation.
What rule? Does that rule have a name?
Yes, sir. I was referring to Generalis Specialibus Non Derogant.
So you're referring to the same rule that to which I referred. But
so that is what the court is, and we responded to it in paragraphs 30, 31, 32, saying that they've essentially got the interpretation wrong.
Okay. Thank you. But isn't it correct to think that Parliament recognized that offences under the Trademarks Act could very well be committed by companies, and for the abundance of caution, out of the abundance of caution, what Parliament did was to pass a provision in 50E, which itself is a statutory lifting of the veil, so to speak, because that's where your argument is, I think. You're saying that you cannot deny separate legal personality except through that vehicle. But I'm certain that you would agree that Parliament can statutorily lift the corporate veil, and isn't Section 50E an attempt by Parliament? I think it succeeded. Isn't Parliament there attempting to, as it were, create a statutory lifting of the veil?
I think that that's what they're attempting to do. And I think the question for this court will be whether the impact of 50E is to abolish the rule in the Interpretation Act in Section 22. And we're saying that it is not.
Mr. Pilgrim, could we also look then at Section 22? Because it's an interesting formulation. It says, I skip a few things, but I go to the essentials. Where an offense has been committed by a body corporate, the liability of whose members is limited, then notwithstanding and without prejudice to the liability of that body, any person who has a certain function in that company, that body, will be liable to be prosecuted as if he had personally committed that offense. And then it comes to, so it is as if he had personally been guilty of that offense. So that is a way the criminal law wants to get around the corporate structure to get to persons in a certain position. But here we have a situation where it was not that as if he had personally committed the offense. Here the indictment is that he personally committed that offense. Not as if. And in a case like that, would it still be necessary? Would Section 22 still be applicable? So that it seems to me that there are three ways of prosecuting these kind of crimes. First, if somebody personally committed a crime and fulfilled all the elements, then there is simple prosecution of the person, whether or not he acted in the company's context.
Yes.
However, that is going to be difficult because it's not always that easy. But it is clear that the crime was committed by a body corporate without knowing exactly who did what. In that case, you can sue or indict, you can indict the company. But then there's the third possibility that you can indict the company. You can't explicitly say, well, this person did this or that. You can't point at a person who fulfilled all the elements of the crime, but you can say, well, I I know that a company did this, and I also know that this person is, let's say, a director, and that he knew about this, the elements that you will find in 50E or 22. And that is a way to get around it. Now, that is a complex exercise, and 22 seems to say, before you do that, you really need to consult with the DPP and get his or her kind of blessing to charge. Now, so those are three possibilities, it seems to me, that can occur. But in this particular case, it was not that construction of 50E that was used, because that's not in the indictment. The indictment doesn't mention anything about him being a director, as I understand it, or that he had connivance or whatever. It says simply that he did all these things personally. So in that case, does 22 apply at all? In a case where the indictment says that the person did this personally and complied and fulfilled all the elements of the crime. Does 22 still apply in a situation like that?
If the investigator is in a position to say, I can go against the company or I can go against the individual, I'm of the view that the individual has done all of the acts, but I have a choice. And the Crown, I think we all agree, I think at bare minimum, that they had a choice. Mm-hmm. And as our Court of Appeals sought to deal with that by saying, well, we're not at the stage of committed yet. We don't know who committed the offense, as I understand it. But I think the moment that they had that choice, there was a protection that would have obtained, that the defendant had an ability to benefit from.
But if that was the way to get to Mr. Delpeache, so to speak, shouldn't the indictment have said that it was the Ouch Boutique that committed this offense, that he, Delpeache, is the director of the company, and that he knew very well that these things were happening, and therefore that he is also liable. But that is not in the indictment. The indictment goes straight to him and says, you did this and this and this. And that is a criminal offense. So that's a different approach. Because in the 50E approach, or the section 22 of the interpretation approach, you don't have to show that Mr. Delpeache really did those things. It is enough then to say, well, the company did it, you are the director, and you knew about it. But that is not the approach that was taken.
Your Honor, I think that I would want to approach it from this standpoint. What is the purpose of putting the DPP in a position to advise on whether to go against the company or to go against the individual? Parliament, in its wisdom, decided that the DPP should have a role in that process. That is the impact in our submission of 22, to ask the question, when you are going to decide whether a person should be charged individually in their own capacity or whether the company should be charged, the DPP should be consulted. And the reason for that, I imagine, is to protect individuals who are involved in corporate practices and who may want to continue in corporate practices. And they want to encourage business. And this is I don't want to go over the history of the act and so on, the reasons for it, but there's a reason for that. And that protection exists, we say in 22, for exactly that reason. So that the DPP could say, well, this is a very low standard, for example, in this section, and we don't think that an individual should be exposed to this because it may prevent them being able to do business in the future. That if he gets a conviction of this nature, he may be, for example, banned from travel to the US. He may lose his bank accounts. People in business may say, we will no longer deal with him, Delpeache, because of this. And that these are things that Section 22 is protecting. Section 22 is saying, because we do not want to damage people in business without careful review, the DPP should have a say.
So, Mr. Pilgrim, are you suggesting to us then that without that say of the DPP, your client should not have been charged? He could never have been charged in his personal capacity without praying in aid either 50E or Section 22?
With whether he could be charged without praying them in aid?
In aid, those sections.
Essentially, yes. The short
us?
version is yes. That the DPP ought to have been consulted before he was charged because of what is stated in 22. And that it is inappropriate to say, well, we could get at him through 50, so we don't have to go through 22. We're saying that 22 provides a protection for me. Help me. Don't go straight because there's another route. This route exists for a reason, and it invites the Crown to go through a process to protect people like Mr. Delpeache.
But is the protection not because, as this section says, you're now prosecuting somebody not because he committed an offense, but you're prosecuting somebody as if he personally committed the offense. That is a construction which requires some more thinking. And in a case like that, one would want the highest officer in the public prosecution to have a look at that. But if somebody personally committed an offense, is it still necessary for the DPP to look at that? So that is my question.
I think the question is whether the DPP, well, first of all, I don't accept that the DPP is overburdened with situations like this. One, I think this is rare.
Yes.
And indeed, prosecutions under the Trademarks Act in Barbados seem limited to the activities of Rihanna. But it just seems to me that this is designed to protect people. It is designed specifically to ensure that we don't knock individuals out of business.
Okay. Is that what you want to say about the second point?
Yes, Malad, I just wanted to go on and make the point that the Crown's position that we haven't proved that this was not done is disingenuous. And that to say also that they're not aware of the forms is also disingenuous, because they're aware that the Crown does this.
Mm-hmm.
And they know that they can do it without any form. They can write a letter saying this is what the position is. And indeed, I was trying to get my hands on a letter from a case I have pending called Commissioner of Police against Ahmed Yusuf, but I've been unable to get it, in which the DPP writes a letter essentially granting this permission, saying that I accept this and please go ahead. So that their arguments seem to be, oh, there's no forms, and even if there were forms, we could do it and we don't have to tell you. But the answer to that must be no. This is to protect me. And therefore, if you are doing it, and this is apart from the earlier argument, but if we can accept that this is something that should be done, and you are doing it, you have a duty to tell me that it's been done. So that in this case, in our view, the starting point is for the Crown to disclose whether it was done or not. In other words, the Crown have not answered the question in this particular case, whether the DPP was consulted and whether he or she gave permission at all. And I think that surely should be their starting point. I suppose it may be implied from the fact that they're saying there are no forms that it wasn't done, but I don't know that. They're also saying, they make the argument that it doesn't have to be in writing. So maybe they're saying it was a consultation oral that they don't want to tell us about. But I imagine in the context of this appeal, the starting point for the Crown would be to say, we did not do this, and we don't think we have to, and that's why we didn't. or we did it and we ain't telling you. But I imagine that the Crown, in the context of this appeal, cannot get off the ground without telling us whether this was done. And then saying, if it was done, here is the document, or this was a conversation that took place between DPP Leacock or DPP whoever was in place at the time, and it was with investigator Jones or Phillips. But not to say that we don't have to tell you. That cannot be the answer.
Mr. Pilgrim, assuming that the Crown is right, that Section 50E applied to the case before you, did the prosecution support the ingredients of that section? Would you say that the prosecution invoked that section and satisfied the various components of the section?
Yes, Your Honor. I don't think I can say otherwise.
You don't think you could say otherwise?
No.
Okay, thanks.
And this is 50E or 50A? I'm sorry, I didn't hear it at my end.
E.
Thank you very much.
Yes, which is the alternative to Section 22.
Thank you. Mr. Pilgrim, you're going to take us to your first round now?
Grateful, Your Honor. I think we made it clear that our position was that the Crown needed to get beneath the veil. They need to have the veil lifted in this matter. But their position is they don't have to, they can go direct. And they are arguing, as I understand it, that in their paragraph 13, which is page 662, in their paragraph 13, it is agreed that on the facts in this case, charges could have been brought against Ouch Boutique. However, it's submitted that the liability of Ouch Boutique does not preclude the appellant from being held liable personally, as has been done in this instance. It is submitted that as held by the Honorable Court of Appeal, the appellant is guilty of the offences not in his capacity as the director of a one-man company, but rather he is liable as having personally contravened the Trademark Act, having possessed the actus reus and mens rea. And the respondent further submits that in this matter, there is no doubt as to who is the real actor. So essentially, their entire position is that they're entitled to go behind, they're entitled to lift the veil. And that they don't have any obligation to do otherwise. Their position essentially is that the veil they're entitled to lift it and they have lifted it. And they have no obligation to do otherwise. And we are saying that there are certain...
Mr. Pilgrim.
Sorry.
If you look at 50A1A, are you with me?
Yes, sir.
He was charged under that provision for applying to goods and so forth, etc. Wasn't he?
Yes, Your Honor.
Is that an offense which the company could have committed? What I'm wondering, let me put the question differently. What I'm wondering is whether you're lifting the veil, whether it's necessary to lift the veil to prosecute under 51A. Isn't it possible without any corporate intervention for a person to apply to goods a false trademark?
I think the question that the court is asking is whether an individual can be charged under that section. I think the answer is yes.
The question is a little bit more to your argument. Remember that you're arguing that the Crown is saying that the veil has to be lifted to get at the various charges. Now, the charge which I'm looking at is the charge under 50A1A. And a person who commits the offense of applying to goods. Doesn't matter who the goods belong to, but he applies to goods. A false trademark. Where does the corporate personality come in there?
Or in other words, where is the veil?
He's trying under 50A1A. Just for clarity, Your Honor, I don't think we're referring to 51A.
Okay, I'm glad you're not.
So what are you referring to?
It's 50A1A, Mr. Pilgrim. 50A1A.
I thought it. I don't know where. I'm laboring under the illusion all the time that we're under B, because there's no suggestion that he applied to goods any mark.
But he was convicted for that offense, wasn't he?
I don't know. Well, perhaps that's an error that we've all made all along, because he should not have been convicted of that, because there's no evidence that he applied to the goods any mark or sign at any time. So I think he could only be convicted under B.
Are you suggesting to us, Mr. Pilgrim, that there is evidence as to B?
Perhaps I should say I was suggesting there's no evidence as to A, but their case was under B. Their case is that he offered for sale.
But wasn't he charged under A, B, and C? Mr. Pilgrim?
Yes, that's correct, sir. Sorry, Your Honor. I think our position is, and has always been, that there's no evidence of A, and there was no effort at any time to lead evidences to A, but there was evidence led as to B, and I think he was charged under A and B together.
Well, it's a little confusing. You mean 50A, 1B?
50A, 1B is what they have led evidence of. They have not led evidence of 50A, 1A.
C.
What about 1C?
I don't think he was charged under C. He is? Yes. C as well? Yes. Yes, the possession and the sale are the things he's charged in respect of. He's also charged under A, but he should not have been in our view, because
merged it with B.
So
he would not have done that.
So you said there's no evidence of A, but they led evidence of B and C, is that right? I'm just trying to get my, yes.
But Mr. Pilgrim, you didn't appeal in respect of lack of evidence in respect of 51-1A, 50A-1A. Did you?
We did at Court of Appeal level, yes, Your Honor.
And we did hear, but
we were only granted in respect of two grounds.
2 points of law?
2 points of law, I beg your pardon, Your Honor.
Thank you.
But I don't think it's in dispute that. In other words, is where you are the person out there taking the Puma or the Nike swoosh and putting it on shoes and doing that. There was never any suggestion in the Crown's evidence that he was that person. They're saying he was in possession, and they're saying that he had them on sale.
Sorry, could we just clarify that point? I see Ms. Davis has her hand up.
Yes, Your Honors. I have a copy of the charge sheet. This is attached to the bundle from the Magistrate's Court. It appears that he was charged under Section 50A, 1, big A, small b, and then Section 50A, subsection 1, 50A, subsection 1, clause C.
So is Mr. Pilgrim right then? He wasn't charged for applying?
Sorry, my lord, but Your Honor, 2 counts for B under subsection B.
So is Mr. Pilgrim right?
I don't believe he was charged under subsection A, Your Honor.
So 2 counts under subsection B and 1 count under subsection C. Is that right?
That is my understanding, Your Honor.
Yeah, okay.
So he was not charged for applying?
Counsel, if I may help, I am looking at the decision of the Court of Appeal under paragraph 20, the magistrate's findings, and the second extract from the magistrate's summarizing his finding is, I find that the defendant was aware of the existence of a registered trademark, etc. He exposed for sale, and contrary to 50, big A, sub 1, A, and sub B. He did this with a view to gain for himself, etc. And then I reject the defendant defenses and find him guilty as charged on all 3 counts.
Your Honor, that seems to have been an error.
Yeah.
Mm-hmm.
That is how the charge sheet that we have before us looks. He's charged that he, under section 50, big A, subsection 1, clause A and B of the Trademarks Act, did certain things.
Right.
But that should have been B and C.
Yeah.
Yes.
Yeah. Mm-hmm.
Okay, so I think we have that clear, and apparently Ms. Davis is agreeing with you, Mr. Pilgrim.
Okay,
So
I thought she was disagreeing.
I'm sorry?
I thought she was saying that he was only charged under B and C, but maybe I'm wrong.
Ms. Davis, you said you will read it from the charge sheet?
Yes, Your Honor.
So is it then that the magistrate, yes, made an error there?
Mm-hmm. Court's indulgence.
You're on mute, Ms. Davis.
Perfectly court's indulgence.
But the body of it refers to.
He has posed goods for sale with a bill campaign to pay. So bill campaign stock posed goods for sale.
Yes, Your Honor. I have that he was charged on the 50A1, big A, B, twice, Your Honors, and then 50A1C, once, Your Honors.
Thank you.
Okay, and what were the concrete facts that he was accused of? Was he ever accused of applying to goods or their packaging a sign identical to or likely to be mistaken for a registered trademark? Was he ever charged with that?
I don't believe so, Your Honor.
But he was charged with selling, with having in possession, And what was the third? The third one?
Just those two.
2 signs on 1 possession.
Just those two.
Any signs and possessions are on the same day?
Your Honor, and it's posing for sale.
Yeah.
Posing for sale.
Everything's in there.
Right, with a view, Your Honors, to gain for himself or another with the intent to cause loss to another and without the consent of the registered owner of the trademark, to wit, Comm'r did expose for sale goods, and then the goods are noted on the charge sheet.
So all of that is fine. So I think, as I said earlier, you are agreeing with Mr. Pilgrim that the charge is related to section.
So I could tell the judges. Back as we were before, just to report that our registered supervisor, she recorded the first session on Teams, so we at least have some sort of recording where that is concerned. Thank you for your patience, judges and counsel.
Thank you.
Are all our judges in, Justice Witt and counsel? Everyone is back?
I'm not sure, but I hope you can.
Justice Lee, are you there? Justice Burgess, Justice Barrow, I'm seeing Justice Anderson. I'm seeing counsel for both sides. Justice Lee, are you there? Justice Barrow, Justice Burgess.
The chairman did mention 10 minutes, so.
Yes, he did, Judge.
As a maximum.
I know.
Sorry, I am back. I had just got off to go and get a pen.
Thank you, Judge. Justice Lee? Justice Burgess?
Present.
Thank you, sir. So I think we're just waiting on to hear from Justice Rush, not Lee. So, Judge, Justice Witt, we'll give her two minutes, please, or you? Oh.
I think she would be here anytime.
Yes, very.
We can't proceed without her, so.
No, we can't. So I will call her on mobile.
Nor would we want to.
Certainly not. Yeah, back, so still I
think Judge Barrow had referred me to paragraph 100.
Yes, and 101.
The essence of which, as you will appreciate, Mr. Pilgrim, is there was no need under the statutory provision to find evidence of benefit either by Delpeache or Ouch Boutique. There was no need to determine whether the property belonged to Ouch Boutique. The prosecution followed the evidence, some of which was given by the appellant himself, to the effect that he traveled to New York to obtain the offending goods to place in his store. He mounted the goods for sale and was responsible for the sale of the goods in the store, Ouch Boutique. And then it is not because he's a director of a one-man company that this matters. Rather, it is because he actually committed the actus reus and had mens rea of the offences charged. There was therefore no need for the prosecution to prove concealment, evasion, shelter, or the existence of a cloak or sham and lift the corporate veil. And then just to, as it were, complete on that, at the last part of 103, we do hold that the appellant was clearly acting as an agent of the company when he purchased the goods, delivered them to Ouch Boutique, displayed them in the store for sale, and actually sold a pair of the counterfeit shoes. this was sufficient in our view to justify his prosecution. Now, it is clear to me that there is not any appeal permitted, no leave was given to argue the evidential point, etc. So what I am left with is this finding on appeal by the Court of Appeal. Is there any assistance that you can give us without seeking impermissibly to argue a ground that is not before us? Is there any assistance that you can give us, Mr. Pilgrim, in this regard?
Your Honor, my reading of paragraph 100 and beyond is that certain assumptions are being made. It is not, I think it's very difficult in arguing this ground for the Crown not to be able to rely on evidence which shows that the appellant did all the things required. I think that they have to be able to show that in order to be able to say we are correct in saying there's no need to go into company law here at all. I think the only way that they can say lifting the veil is not an issue and section 22 is not an issue, we're relying on section 50, etc., is if they can say happily that they can prove that the elements of the offense were all committed by Mr. Delpeache personally. And while there is evidence that Mr. Delpeache went to New York and bought the items to stock his store, or to stock the store, there's also evidence, he says in his own evidence, that Ouch Boutique owned these items, and these items were displayed in the store Ouch Boutique.
So if I understand it correctly, your argument is that the fact that there is some kind of, I think you call it protection for the Mr. Delpeache in this case, is not suggesting that you can escape criminal liability by establishing a company or by incorporating a company. You're saying, if I understand you, that the person can still remain criminally liable for these kinds of acts, but there is a procedure which must be observed.
Yes, Your Honor.
Before criminal liability can attach. And I think you gave your reasons as to why you think Parliament went in that direction. I must say though, and I hope I'm not curtailing how you're developing your argument, that you responded to my brother Burgess in a way which was surprising when he asked you about section 50E. I wanted to return to that at a convenient time for you. I don't know whether...
No, it's good, sir.
Now it's good. Okay, because you said, if I heard you correctly, that all the ingredients of 50E had been satisfied, so that you would not be able to raise a defense under 50E, and that is why you're going for 22. Is that your considered and final opinion on this? Because the opening words of 50E speak to the issue of an offense having been committed by the company. Mm-hmm. And in those circumstances, persons connected in the ways described in the section can also be held liable. But in this particular case, I'm not sure that preambular statement was satisfied. Was it? Was there established to be an offense committed by this company?
If I may as well, President of the Tribunal, I'm glad that my brother Justice Anderson revisited that, because I was slightly surprised to hear the answer which you gave, and perhaps Justice Anderson's intervention here may give you an opportunity to explain exactly what you mean.
I think I'm a little bit unsure of what Justice Anderson's question is. I beg your pardon, but I think the question that I was being asked by Justice Burgess earlier, as I understood it, was, do you accept that the Crown are entitled to proceed against the appellant individually under 50A? Right? There's no doubt about that they can.
Yeah, that was on the assumption that he'd been charged under 51A, but that has now gone through the window, and it is now obvious to all of us that he was charged twice under 50, etc. B, and once under C. But the question which I raised with you was assuming that he had been charged under 51A, but that's not going through the window. But the question on 50E was a very different question. That question was, as Mr. Justice Anderson's question to you is pointing to, there are certain ingredients which have to be proved under Section 50 to invoke 50E. I think Mr. Justice Anderson pointed to one such thing that must be proved. And I raised the question with you as to whether those things which had to be proved under 50E1, whether these things were proved.
Well, and maybe I can add to that. It's not just that they have to be proved; they have to be indicted. They have to be in the indictment.
Yeah, thanks very much, President. Yes, that's a very important point.
I think that the court understands me to be saying, I hope, that if the Crown want to proceed against Mr. Delpeache as an individual, they must prove all the constituent elements of the offense against him.
Yes.
And we are saying that on the evidence in this case, they cannot.
You are saying, as I understand it, okay, on the evidence as it is here, they could not prosecute him directly on the 50A1, B, or C. They should have prosecuted him under 50E because he did not do these things personally.
Yes, or they should have proceeded against the company.
Or against the company. I think that is agreed that they could have done that. They didn't do that. But if they want to get to Mr. Delpeache, you are saying, yes, you can indict him, you can prosecute him personally as they did, but not under the evidence that was here.
Correct, Your Honor.
If you want to use the evidence that was here, then they should have followed the 50E route. Is that what you're saying?
Yes, Your Honor, and that therefore Section 22 would have applied as well.
Okay, that is clear.
We're in your hands, Your Honor.
This is what you want to say?
Yes, Your Honor.
Okay. Well, thank you very much.
Thank you.
Sorry, Mr. President.
Sure.
There's just one question, the question of principle, which I'd like to raise with Mr. Pilgrim, if I may. Okay. Mr. Pilgrim, your submissions, you relied heavily on common law principles governing lifting the veil. Do these principles apply in light of Section 50E? Do these, isn't 50E a statutory route for getting at directors and persons within the company? Is it necessary, or can one now resort to common law principles of lifting the veil? Because I saw you you dealt extensively with Preston Petrodel. The question I'm raising with you is when you are dealing with the Trademarks Act and corporate individual liability, isn't it covered? The question of lifting the veil, isn't it covered by 50E? That's a question of principle which I hope you can help me on.
You have to unmute, Mr. Pilgrim. You have to unmute.
That mute button really is bedeviling you, Mr. Pilgrim.
Go again.
Yes, Mr. Pilgrim.
Can you hear me now, sir?
Yes, we can.
Okay, our button is still saying that we're muted, so we're a bit confused. Let me see if I understand your inquiry, Your Honor. I think the question you're asking is whether 50E takes away any need to lift any veil or gives an automatic lift of the veil.
I think
that's what I'm wondering. If it is in light of the fact that there's a statutory lifting of the veil in 50E, whether there's any need when you're dealing with the trademark considerations under the Trademarks Act to lift the veil via the common law route, because you expended a lot of time on the common law rules governing lifting the veil. But the question which I'm raising with you, and it's just a question of principle. If you haven't considered it, you haven't. But I'm just raising it with you for if you could lend any assistance to the court.
Your Honor, I think that the circumstances of this case suggested to me that the common law principles would still apply. I don't know if that's helpful.
I always thought that this was just a tool. This is how you pierce the veil. This is what you use. So first of all, it's a matter in criminal law. The prosecution has to prove something. They have to prove that the crime was committed or the offense was committed by the body corporate. And if you can prove that a person is, let's say, a director or some other officer of that body corporate, in that case, he can also be guilty, or she, under certain circumstances, which are mentioned here. So doesn't that simply means this gives you the tool how to get through the corporate veil and get to a person in the company?
That 50E is the tool, you know?
I thought he was saying 50E is the tool.
We're unmuted, right?
Yeah, unmuted.
Can the court hear me?
Yes. Yeah. So 50E says, well, you can get through that corporate veil and get to somebody with a certain position in the corporate body, if you can prove that the act happened with the consent or connivance, etc., of that particular person, then you can get to that person too, and convict him of that same offense that was committed by the company. So would you then need anything else but this instrument?
I think that the instrument can satisfy that, but in my view, the 22 stands in the way of it. Something has to happen before that.
Well, yeah, that's another issue. But
yes, sir, I agree then.
Yes. Okay, good. So then we can go to Ms. Davis.
Yes, good morning, Your Honor. Firstly, I relay on my written submissions in relation to this matter. I wish to point out to the court, however, that our position remains that Section 50E is applicable as opposed to Section 22 of the Interpretation Act, simply because Section 50E is specific and concerns the offense under the Trademarks Act where a company is concerned. Section 50E does not. Sorry, I'm getting feedback. Section 50E does not prescribe that there should be any direction from the Director of Public Prosecutions in relation to going against a person as if they committed an offense. And I understand what my friend is saying in terms of the fact that incorporation must have some meaning, but it does not extinguish the personal liability of a person in relation to the Trademarks Act. Trademarks offenses are very serious offenses. This is a very serious global crime. And how Parliament has chosen to approach this crime is reflected in Section 50E, where it provides that a person, once certain things are satisfied, can be held personally liable in relation to this particular offense. And what I would say further, in terms of ground.
Ms. Davis, let me just, for clarification, please. You're not saying that the Crown pursue this matter under Section 50E. That is not what you're saying to us.
No, Your Honor.
Thank you.
So in fact, you're saying neither 50E nor 22 of the Interpretation Act apply?
Yes, that is correct, Your Honor. They do not apply to this case, but if the company was charged in this matter, Your Honor, Section 50 should have been the relevant section. There would be no need to have gone to Section 22 of the Interpretation Act.
Yes.
That's my point.
And just to be clear, now suppose that it did apply 22, then in that case you would need a direction from the DPP. I know that you're saying it doesn't apply, certainly not in this case and not generally in these kind of cases. But if it would apply, then you would need some direction from the DPP. And then the submission is, in that case, you need to have it in a written form, although that is not in the legislation. But the whole charge depends on that direction of the DPP, because you're not allowed to charge without that, says 22.3.
Yes, yes.
Is it the opinion that if 22.3 applies in a case like this or any other case, you would need to have something in writing to show that you would have to at least be able to say that, yes, we did get directions from the DPP? If so, should that be in writing or some other form? What would you say about that?
I did address that in my written submission, Your Honor.
Mm-hmm.
The legislation does not specify the form of that direction. I understand my friend's arguments in relation to that. There should be something to show, but there really is no mandate that it has to be in writing.
But you would have to show. How would you show it?
It should be on the record of the magistrate's court in some way, Lars, whether it was taken orally or it could have been in written as well, Your Honor.
But wouldn't evidence have to be led in the magistrate court in that regard? And was it led?
I believe it would have to be, if that situation was, it would have to be led. It would have to form part of the magistrate's court record. But remember, Your Honors, in this case, we went against the appellant in his personal capacity. So there was really no need for section.
We understand that, but just for our understanding, if it had been applicable, there will be other cases where it will apply. And then we just want to know You say, well, that if that is a question, then we have to show that, not necessarily in that we have to show something in writing, but you will need evidence, because the charge, according to that section, depends on the consent or the direction of the DPP. If you don't get that direction, I'm not saying in this case, huh?
Sorry, Your Honor. Sorry, Your Honor. The attorneys for the appellant appear to be out of this meeting.
He said that he got bumped off. He's just he's trying to reconnect, sir, so he's not here at the moment.
Okay,
but Mr. Pilgrim is not here right now.
Okay, we'll have to wait.
Judge will send him the link. I'll have one of the CM will send him the link.
Okay.
Just give us a minute, please. Thank you.
Yes.
We hope that it is not his mute button which is causing this further problem.
I suppose this goes beyond mute.
We just admitted him back in. Counsel, are you seeing him? I'm not seeing him on my screen. Is he there?
I'm not seeing him.
We just admitted him back. I think I'm seeing. Okay. Mr. Pilgrim, are you there? Are you hearing us?
You have to unmute again.
Hi, Mr. Pilgrim, we're seeing you. Are you hearing us? Are you seeing the bench?
No. Not seeing the bench, but we're hearing you.
But you're hearing? All right. So
yes.
Justice Witt, judges, are you hearing, Mr. Pilgrim?
Yeah, we are hearing.
Yes,
yeah, we are.
We are seeing and hearing him.
Thank you, judges.
Yeah. Okay, so I asked the question. So suppose 22(3) of the Interpretation Act would apply. Don't you agree that you will have to show the evidence that there was some direction from the DPP and how? Well, that is the question. Don't you think you have to prove that? If you cannot prove that, then the charge is well, maybe no. How do you see that, Ms. Davis?
Yes, Your Honor. I believe that there should be evidence in the magistrate's court record that has been done if Section 22, the Interpretation Act, applies in the matter.
But that does not necessarily have to be written evidence. That could be evidence given by some officer or whatever.
It could be, Your Honor, because there's no specification that it has to be in written.
Okay.
So you agree then that if this point goes against you, the appeal must succeed?
Well, Your Honor, my position is that where a company is involved, that Section 50E is the applicable, is Section 50E prevails over Section 22 of the Interpretation Act. Section 50E.
Yeah, but that's my point, that if we were to decide against you on that point, then the appeal must succeed.
Your Honor, I'm understanding your question to be that if the court is deeming Section 22 to be applicable,
yeah.
Yes, Your Honor.
Okay.
Okay.
Good. Thanks.
That's clear. Okay, you can continue.
Yes. As the court did rightly state earlier, the indictment does not mention the appellant's status as director. We have proceeded against him in his personal capacity. Mm-hmm. I just made that the next point that Section 50E would prevail if the company was charged in this matter. In relation to ground one, I submit that the The appellant did not raise any defense that there was another actor. I made that note given the discussion in going into the evidence earlier, but Your Honors, the magistrate is the finder of fact, my lord, and Your Honors, and there has been no defense, no successful defense proffered by the appellant in relation to this charge. I submit that he's rightfully convicted of the offenses before the court, unless the court wishes to hear me further on any issue on this matter.
I want to sort of pursue that line with you a little bit. You say that there was no need to lead evidence that he was a director of the company because the charge was against him personally in respect of what he had done and his state of mind when he did it.
Yes.
Mr. Pilgrim, on the other hand, is saying that, well, as long as a company is involved, there are certain protections which are given to persons such as Mr. Delpeache. Now, what is wrong with that way of looking at it? Because Mr. Pilgrim gave, I thought, a fairly cogent explanation as to why that should be so in terms of the encouragement of business and so on. And we're not sort of considering a case of impunity because there is a way at which you can get not just at the company, but also at the individual, provided you follow certain procedures. So what is wrong with that way of looking at it, the way that Mr. Pilgrim advances?
Well, Your Honor, the Crown did not agree that it was the company who performed the offense. Our position always was that it was the appellant who did the actus reus mens rea of this offense. We submitted that incorporation, that the fact that a company is involved, that a company is, that he is a director of a company does not extinguish his personal liability for.
But you would concede, Ms. Davis, sorry to interrupt, that the goods were purchased for the company. Would you not agree?
Yes, Your Honor, I would agree
and
that.
The goods were housed on the premises of the company?
Yes, I would agree. I would agree that.
Offered for sale in the business place of the company.
Yes, I would agree that.
So I guess the company is, it seems to me, intimately involved in a lot of the activities which are relevant to the charge. And in those circumstances, I'm just wondering what is lost by adopting Mr. Pilgrim's approach, which is to say, yes, there's no case of impunity here. You can go against, Mr. Delpeache or whomever, but there are certain safeguards, I think is the word he used, or protections, which must be observed. Is there anything wrong with that? Is the criminal law not going to be vindicated if that approach is taken?
Well, Learning Council is wishing to proceed. Right. Learning Council is wishing to proceed under Section 22 of the Interpretation Act. Our position is that if that were so, it would be that the particulars are Section 50E, which must be satisfied.
Yes, but in this case, you did not attempt to satisfy 50E either, did you? You see, part of what I'm wondering is as you said right at the beginning, and I was very attracted to the point you made, that the regime in the Trademarks Act was intended to ensure that Barbados respected its international obligations. And indeed, I believe the Act says that it was passed for the purpose of carrying out international obligations under, for example, the Paris Conventions. I do not know, and this is why I'm asking, whether the approach advanced by Mr. Pilgrim would in some way dilute the efforts of Barbados to ensure that its implementation of these conventions was as intended by the conventions. I mean, is that a way that you could sort of respond to the argument that he's making, that in order for the government of Barbados to fulfill its international obligations, the approach that you are advancing has to be the approach to be taken? I don't know, I'm just raising that with you.
Yes, Your Honors. I do agree with the court's view of that issue, because in my written submissions, I did make the point that Section 50E reflects what Parliament's recent intention is in relation to this particular type of offence. This persons tend to view other types of criminal law as very serious, but the global position is that trademarks offences are very serious offences. Persons don't tend to see intellectual property as important, the theft of intellectual property as important as the theft of a vehicle or theft of real property, for instance, or theft of money. But it is a very, very serious offense, which can have disastrous consequences for the trademark owner. And that is why it has to be this way, Your Honor.
Yes.
Counsel, I just wanted to raise a question with you. He was charged under 50A, big A, 1B of, let's take selling, for instance.
Yeah.
Is it the evidence that the goods bought by Ms. Hope was bought in Upch's boutique? Wasn't the evidence also that she was given a receipt, but she insisted that she got a receipt from the company? Isn't this the evidence? So the question for me is, if you are charged with selling, if you're charged with selling personally, does that evidence go to proving that you sold? And doesn't it create the problem which my brother Anderson is referring to, and which Mr. Pilgrim, I think, has identified? Doesn't it create that problem?
Yes, Your Honor. The money did receive a receipt from the company. That's my understanding of the evidence.
Counsel, help me here as a follow-on from that. Mm-hmm. The statement to which I referred Mr. Pilgrim in the decision of the court contains, as part of that statement by the Court of Appeal, that Mr. Delpeache actually sold a pair of the counterfeit shoes. Is that, in fact, in the evidence, and is it something to which you can point?
Criminal court's indulgence.
When you go to paragraph 2 of the judgment of the Court of Appeal, you will find a summary of the facts. For example, it says that Ms. Hope went to the store. She asked the store assistant if they had Puma shoes. She purchased a pair of slippers from the store. Having been assured that they were Puma slippers, she had seen the slippers on display in the store on the top of one of the clothes racks. The sales clerk told her that she did not have her size, but she could wear them, as the size was a bit off. Then she went over to the cashier. The cashier told her the cost of the slippers was $100, as opposed to $200, which she saw on the shoe. She paid by debit card and was given a machine receipt. She asked for a store receipt.
Thank you, my brother, but it is the same judgment which in paragraph 2 gives that narration of what that witness says. It is in the same judgment that the judge finds that Delpeache actually sold a pair of slippers. So I wanted to see if the judge was fabricating or inventing this, or if there was in fact some piece of evidence to which I could direct my attention to see if it was sound. So I'm seeking counsel's assistance in this regard.
Yeah. But I suppose you won't find the assistance in paragraph 2 because
that is correct. I have read paragraph 2. I have also read the other paragraphs. So therefore, needing the assistance of counsel, I'm asking for it.
Correct.
Yes, Your Honor. I am looking at the record from the magistrate's court in the actual evidence of Monet Hope at page 22. He stated to the bottom at the second last line that this is the receipt. She sees her initials MH on the back of the store copy. It has Ouch Boutique and an address on it.
Right, but you see, my difficulty is that not all the evidence came from Ms. Hope. Evidence came as well from Mr. Delpeache, who, for instance, said that he went and he bought the things in New York. I have not read his evidence because I was not looking at the evidence for the purposes of this case. But now that the question of evidence has come up, I guess I will now need to go and read his evidence and to see where the Court of Appeal got this very clear statement. So move on, I will find it if it is there, and if it is not, then I will know it does not exist. Please
Your Honor, Your Honor, perhaps from page 46 of the magistrate's court record would assist the court.
46?
From page 46, the questions and answers to Mr. Delpeache, from 46 all the way to...
But is that page 46 of the record?
Of the magistrate's court record, Your Honor.
Is that is before us?
It should be, Your Honor.
Okay. Move on, Counselor. I will find it for myself, if it exists. Or find its non-existence for myself equally.
Your Honors, I don't know if it assists, if the court can hear me.
Yeah.
Because at page 43, again, I don't want to trouble the screen, so we're going on another screen just to get the correct page in your record. But page 43 of the original transcript of the trial, Mr. Delpeache, the fourth line from the top says, Ouch sells these shoes. I do not sell them personally.
That's page 1247 of the record of appeal, which is before us, Mr. Pilgrim.
I believe so, my lady, but I didn't want to trouble the screen to check it. So if we just
I have. It appears so. Page 1247 of 1273. And that is your page 43.
Yes, Your Honor.
Does he say a different thing at your page 46, Ms. Davis?
Yes, Your Honor. A difference. Your Honor, page 46. Your Honor, page 46 is perhaps in the middle of his evidence at magistrate's court. A series of questions in relation to what his admissions.
And what is he saying there?
That's page 1250 of the record. Yeah. That's his cross-examination you want to take us to?
Yes, Your Honor. Craving the person does.
Yeah.
Yes, sir. He does not admit in his cross-examination that he sold any of the items. He did admit, the appellant, sorry, did admit he attached the price. He admitted that he did purchase the items from overseas.
Which page are you looking at?
I'm from page 46, Your Honors.
Yeah. Which one are you looking at where he says that he attached the price to the item, etc.? Just to get clear.
Criminal course indulgence. Page 49, Your Honors.
Yeah, what's a CCJ record? Page 43 is 1247, so I guess this would be 15 something.
1253 to 1254, Judge.
Thanks,
To the court.
Thank you. All right, Counselor, I will not detain you any further on this. Like I said, I will look at it. Look for it.
So he doesn't know he sold. Does he admit that he had anything in his possession? That he had those items in his possession, or that item?
At page 53 of the Magistrate's Court record, Your Honor, when asked, had them in your possession as genuine Puma haversack? He replied, yes, sir.
Page 53?
53 of the Magistrate's Court record.
1257?
Mm-hmm. 57.
1257.
Counsel, I would urge you notice how her leadership has to be supplying the record, the page number of the CCJ's record. In future, you and all counsel need to make your submissions to this court by reference to the CCJ's page numbers. Otherwise, we have having to flip between two different numbers for pages. So I urge you for future. All right?
I apologize to the court for that, Your Honor.
No need, just for future.
Unless there's any other issue with which I can assist the court.
So the point is, if there would be no evidence which says exactly that he was selling or from which you can derive the conclusion that he had in his possession or whatever, if there is no such evidence, could he still be charged personally as having committed this personally, or should you then indict him under 50E and make use of the fact that he's a director and that he knew about certain things?
Your Honor, there is evidence of possession and that the appellant did display the items for sale.
But is there evidence that he sold them?
Not on my review of the Magistrate's Court record at this time, Your Honor.
Okay. Okay, well, that is clear. If nobody else has questions, then maybe Mr. Pilgrim, you can round it off.
I suppose it would have been different, Ms. Davis, if he was selling them from his house. It would have been easier for you, would you say?
Yes, Your Honor.
It would have been easier, yeah. Okay, thanks.
Mr. Pilgrim.
Your Honor, I just wanted, well, not to belabor the facts too much, but at page 1257 of your record,
yeah.
In answer to a question, you sold these bags as genuine Puma haversacks? He responds, I did not sell any of the bags I bought as genuine. You had them in your possession as genuine Puma haversack? Yes, sir. You were there to sell, correct? Yes, sir, in the near future. These bags were found on display in Ouch. They were not on display for sale, but in the stock room would be moved for sale eventually to the floor. I think those are
the slippers that were sold were there on display because Miss Hope would not have seen them if they were not in the store. Isn't that correct?
That is correct, but she also states that she received a receipt from Ouch Limited, and there's no indication that he had any role in that sale.
Yes, yeah, that's clear. And I think Ms. Davis is also saying that she doesn't have any evidence that he sold it personally.
Indeed, sir.
Anything else?
No, I think. Your Honor, I'm just tempted to mention the fact that this and many of the cases that we have in the magistrate's court present us with problems because there's still no recording. And we had complained as a ground, a substantive ground before the court below, that the record was incomplete and at times did not make sense. And 1257 is just another example where the answer doesn't seem quite to add up with the question. And it is a challenge when a magistrate is taking everything longhand. And obviously that doesn't mean we can't have magisterial appeals. I'm not saying we shouldn't, but over the years, there have been many indications that recording equipment was available. At the last stage, I think the OAS was supposed to have donated this amount of equipment so that all of what was said in the magistrate's courts could be recorded and be made available. But it always comes back to the long handwriting of the magistrate, which seems, in our view, to contain gaps. And we argued that point below because there were certain aspects of the evidence that didn't seem to add up or make sense. And that is part of the challenge that I think we face with all of our magisterial appeals. But just for example, at page 1257, you were there to sell, correct? Yes, sir, in the near future. It almost seems as if this answer could be in part to what is being asked, but it's not entirely clear. And it's one of the challenges that we face quite often. And I don't know if a statement from this court about how useful it would be to have a transcript of what takes place before the magistrates would have any influence or bearing on things going forward.
Has that matter been corrected now, Mr.
No, ma'am. No, Your Honor.
So there,
magistrates are still taking longhand?
Sorry, ma'am?
Magistrates are still taking notes of evidence in longhand?
Yes, Your Honor. In all matters.
And there's no magistrate's court where they have at least try out a system like this?
Your Honor, I can recall that while I did not do the Delpeache trial, that I was in court that day and there was certain equipment and there was talk of testing it. But that, as you will appreciate, was several years ago. And as far as I'm aware, not as far as I'm aware, I'm in these courts every day. And we're getting no transcripts. There's equipment there, there's a computer, there are microphones, some taped to the floor, some taped to the desk, but nothing is happening.
Okay. That's it?
That's it, sir.
Okay, well, thank you very much, Counsel. We will deliberate and as quickly as possible, we will let you know when we can deliver the judgment.
Please.
Should be hopefully within 3 months, but that's what we try to do at least.
We're grateful to you, and we know that there are extra challenges to how we do business now, so we're cognizant.
Thank you very much. Madam Deputy Registrar.
Thank you, Honourable Mr. Justice Witt. Thank you, Honourable Mr. Justice Anderson, Madam Justice Rajnath-Lee, Mr. Justice Barrow, Mr. Justice Burgess. Thank you, Counsel. Thank you, staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.